The Supreme Court of Appeal in Bloemfontein has dismissed former President Jacob Zuma's medical parole appeal with costs. Zuma and Correctional Services challenged the SCA order, which declared his release on medical parole irrational, unlawful and unconstitutional. Now, Correctional Services says it will appeal the ruling that Zuma's release on medical parole was unlawful. For more on this, we are joined by legal expert Mpumelelo Zikalala. Mr. Zikalala, thank you so much for joining us this evening. Now, what did you make of the Supreme Court of Appeal's ruling stating that the medical parole granted was unlawful?
Well, my interpretation is that the SCA was right in a certain stance. However, it was incorrect, or it's got its judgment wrong in another one. It's correct in the following: the interpretation of the Correctional Services Act, the importance of the role of the medical report or the medical expert, and the must or essential consideration of that particular medical report by the commissioner when making a decision. And if the commissioner is going to take a decision which is against the advice of the medical experts, then they must be able to come up with plausible reasons of why they are doing so. However, the legislature would not have inserted the need of medical experts if that particular recommendation would then be ignored by the commission. So in this case, there's nothing which is maybe that contains any exceptional circumstances that are there as to why the commissioner then chose to reject the report or recommendation by the medical expert. However, where I felt the SCA was wrong is when it said that the matter must then go back to the commissioner to decide whether the months in which the former president has been let out of medical parole should be considered or not, because we're basically saying to him, we want you to go and practice a piece of authority in which you don't have. Let's remember, the commissioner is guided by the Correctional Services Act in this case, and the commissioner does not have authority to increase or decrease the punishment or the term of incarceration of any inmate that is there. They are there only to preside over the duration of that particular incarceration period. Now, what you're going to have practically is a former president going back to jail, spending an extra 2 months before he's eligible for parole. That's even before he applies for parole. And the results of that are that instead of going to prison for 15 months prescribed by the Constitutional Court, it's now going to be 17 months. Now, the question that we must all ask ourselves is, in the principle of fairness, in the principle of preserving his rights as an innocent applicant in this case, is that fair? And if the answer to that is no, then definitely the SCA misguided itself in terms of that particular order.
So based on that, are you then saying that the Department of Correctional Services does have a leg to stand on with regards to the appealing that they will be putting forward?
Not necessarily. The most person would be likely to win in that particular appeal would be the former president. When it comes to the department, I don't think that it can win at the end of the day, because the Act is quite prescriptive. It then tells you that if you are going to consider medical parole, the report from the medical expert must be considered. It forms part of the essential elements or the essential things in which you must then consider whether you want to grant parole to an individual or not. Linked to that would be this. At the end of the day, when one takes a decision as a decision maker, you must make sure that your decision that you are taking is lawful, reasonable, and procedurally fair. Now, the element of reasonability will have to come in here in terms of saying, have the decision that you have taken rational. When you've looked at the elements that are in front of you, the facts and the piece of evidence that is in front of you, would the person in your shoes would they have taken the same decision or not? If the answer to that is yes, then your decision is correct. If that answer is no, then it is not. Now, it does not make any rationality when you are going to be recommended by a medical expert who are going to tell you that this particular inmate can be able to stay in jail. There are no exceptional circumstances or even circumstances that would warrant them being released on medical parole. And you decide to go against that particular report without anything which goes in dispute or which is going to support your own disagreement with the report, and then take a decision to release someone. So on that basis, I don't think the department is going to win. But an individual who's likely to win in terms of protecting his rights, or the litigant who's likely to win, is indeed the former president.
The Jacob Zuma Foundation has come out to say that the judgment is based on the incorrect section of the law, stating that when a person has been sentenced for 24 months or less, the commissioner has the interest to make that decision pertaining to parole. Please unpack this for us and why this is not the case for the former president.
That indeed correct that the commissioner is the one that takes the decision. However, you have to distinguish between your normal parole and your medical parole. When it comes to normal parole, you have spent a certain amount of time in jail, usually 1/3 or 1/6 of the jail or the prison time that you're given by the court. And then after that, an application is made automatically to the parole board, and that's for normal parole, in which the parole board will then look at the various circumstances which have been highlighted by the Correctional Services Act. However, when it comes to medical parole, there's no prescribed time in which you might have spent in jail. And then they come back and say, on the basis of the medical reports on the doctors that have examined you, what's their recommendation when it comes to whether can this particular facility be able to take care of your medical needs, or are you suffering from a terminal illness which you are not going to be able to survive from, and the next best thing that can be done by correctional services is to send you home, so that, for a lack of a better word, you will be able to go and die in peace. Now, if you are going to take a decision as a commissioner on medical parole, it means that there must be medical evidence which is going to either support or not support the decision of medical parole being granted. In this case, you had submissions which were made by the medical expert or the medical parole board saying that, yes, we do have facilities that can be able to take care of the former president's medical condition, and he's not suffering from any terminal illness that would warrant that he be released on medical parole. And the commissioner in this case went against the advice of the medical expert. Now, in compliance with Section 33 of the Constitution, you must then find plausible reasons of why you are going to go against the recommendations of experts when they tell you that this particular individual can be able to stay in jail. Which is why I say that I do not think they're going to be successful in defending the decision-making process or the particular sections which are in the Correctional Services Act. What I can also concede is that the manner in which the Correctional Services Act has been written, especially these two clauses, it is very badly drafted. So it's easy for one to make this particular distinction between the two forms of parole and the discretion of the Commission. However, if you look at it in its entirety when it comes to medical parole and the processes that must be followed, it is easy to see from the intent that the intention of the legislatures was to say, we are going to grant the Commissioner this exclusive power to grant a person medical parole after they've considered the medical expert reports, which is why a person cannot be granted medical parole if the Commissioner has not received any medical reports that suggest such or that supports that particular application.
Now, Mr. Zikalala, Arthur Fraser, who was the commissioner at the time, who now has been ordered to pay the costs of the applicant, would there be any further reparations against him? Because ultimately he's the one that took the decision for the release of the former president. Beyond him paying any costs, could he face any more reparations with regards to the decision that he has taken?
That would be highly dictated to by the Correctional Services Act. But if there is no offense that is done, because at the end of the day, it's simply a decision or a process of saying, you took a wrong decision at the time, there are certain repercussions that have taken place, we are going to issue an order and which is going to reverse that. However, our particular order must still be just and equitable and be in the interest of justice. So other than the punishment of paying the cost, there's nothing else that can be given, or as a sort of a punishment be given to Mr. Arthur Fraser if the Correctional Services Act is silent on that.
All right. Thank you so much for your time. That was legal expert Mpumelelo Zikalala giving us his account for the Correctional Services Department that is looking to appeal the former President Jacob Zuma's medical parole ruling that was put out by the SCA earlier this week.